This is the final case that we will hear this morning before we take a short break. It is O'Brien versus Denunzio. It is also a 15-minute mini oral argument on the application. Ms. Haas, you can try to reserve some of your 15 minutes, but we ask that you try and manage that yourself. And with that, you may proceed.
Good morning, Your Honor. Trish Haas, Your Honors. Trish Haas appearing on behalf of the appellant Anne-Marie Denunzio. I'd like to reserve 2 minutes for rebuttal this morning. I'm humbled to be standing here this morning, not only on behalf of my client, but knowing that I have the full support of the family law section of the State Bar of Michigan behind me to address this very important issue and trend that we are seeing increasingly occurring in family law cases, which is that in favor of a quick resolution of child custody disputes, the provisions of the Child Custody Act are absolutely obliterated in favor of a quick resolution. This trend is dangerous. It's very harmful to Michigan families. And I'm hoping here today that we can have some resolution, not only for my client, but for all the other families in the state of Michigan that have likewise been subjected to these orders. Your Honors, what I'm asking for this morning is that the custody order in this matter be vacated and consistent with the reasoning set forth in Judge Gleitscher's very well-reasoned dissent in this manner. As the court is well aware by the pleadings filed not only by me, but also the family law section filed 2 amicus briefs in favor of this application, there's been a trend in which custody orders are being entered not only without any record evidence, but also without making any requisite findings under the Child Custody Act. This is very dangerous to families. It has a long-lasting impact. It forever changes familial relationships. It runs afoul of the constitutional protections embodied in the Child Custody Act that protects children and parents alike, and protects that parent-child relationship, and protects the stability that is necessary for children to grow up to be productive adults in society. The court asked us to address 3 specific issues in this mini oral argument this morning, and I intend to try to address each one briefly. Most importantly, MCL 722.271C requires that a court not enter an order that modifies an existing order so as to change an established custodial environment unless there is presented clear and convincing evidence that it's in the child's best interest.
Counsel, let me interrupt you because I expect my colleagues will have a lot of questions, and let's make sure they can ask those, and then if you have extra time, you can use it. So I'm going to start with Justice Clement.
Thank you, and good morning. So if we assume that there was error here, can you explain to me how it's harmful when the court didn't impose when they had the evidentiary hearing, did not impose that lesser burden as if the established custodial environment had been changed by an ex parte order? And the reason I ask that is it seems like and maybe it's fact specific, but it seems like any explanation as to why this error is harmful would lead to like a per se rule that almost any error is harmful.
Well, Justice Clement, the legislature was very clear in its direction that a court shall not enter an order that changes a child's established custodial environment. So the inquiry must be at the time the order is entered. We cannot have a look back period as what the Court of Appeals majority did in this case to say, well, it really didn't change things. That's just simply not fair because first and foremost, the evidence adduced at trial would have been significantly different had the evidence been taken at the time of entry of the order, which is what the legislature intended. There can be no question in a case such as this that when you have children who are living primarily with one parent for years, for a period of almost 10 years, that when you enter an order that absolutely suspends parenting time, that will change the child's established custodial environment. So the inquiry must occur at the time of entry of the order. That is what the legislature indicated when it promulgated MCL 722.271C. And there's been no case law that indicates that it's appropriate for the inquiry to change to, well, since the later inquiry was appropriate, the later evidentiary burden was appropriate, that the order in and of itself was not erroneous. That's not the correct inquiry. We have to look at it from the position of a child. These children's environment was absolutely changed when the court entered an order that suspended mom's parenting time. That changed the child's established custodial environment at that moment. And that is when the inquiry must be made. That is when there must be evidence of clear and convincing evidence that a change such as that in the child's best interest. It's not permissible to have a look back period. And it really isn't permissible to look at whether or not the change actually occurred, because that's after the fact. The inquiry must be made, as the legislature indicated, at the time the order is entered. And there may be orders, Justice Clement, that in fact may be debatable. But an order such as this, with an absolute suspension of parenting time and no opportunity for a parent-child relationship, in no uncertain terms, changed the child's established custodial environment at that moment and was improper. And the error cannot be considered harmless in light of the proceedings that flowed from that. The well was poisoned by the court's interpretation of off-record impressions gleaned from that initial pleading, and the court, as Judge Gleicher eloquently indicated, never changed course, and it absolutely impacted all of this.
I'm sorry for interrupting. So what I'm hearing you say is that you're not asking us to adopt a per se rule that all error is harmful, that it does depend on the facts. And in this case, because parenting time was completely suspended for your client, that was effectually a change in the ECE, and that was enough where to show harm. But there may be circumstances where whatever that ex parte order that is put in place doesn't rise to that level. Is that yes or no? Is that what you're saying?
Justice Clement, I would love for it to be a per se rule, but I think that's impractical. I believe that, yes, in this case, it's absolutely clear that there was a change in the ECE. I think you have to look at the pleadings, though. In this case, it was a request for a change of custody. It was a request for a suspension of parenting time. There's, in no uncertain terms, that request and that entry of that order changed the child's established custodial environment when there was absolutely no contact allowed.
Okay, so this raises the issue, which I think has been discussed in all of the briefing of this bigger the bigger concern that we have when, and I'm not saying that this is what took place in this case, but there are situations where an ex parte order may be required. So how much time is appropriate for that evidentiary hearing to take place where the established custodial environment cannot be viewed as has been changed? Is it hours, days, a couple of weeks? Is 1 month enough time for that ex parte order to go into effect, and then for an evidentiary hearing to take place?
Well, Justice Clement, it is my position that whether it be an ex parte order or whether it be a temporary order, that order should not be entered without an evidentiary hearing having been held first. Now, that doesn't prevent the court from exercising some emergency powers in another matter, in another fashion. However, an order that is going to, on its face, change the child's established custodial environment, the evidentiary hearing must occur prior to entry of that order, and that's absolutely consistent with all the case law and likewise consistent with the requirements of the Child Custody Act. There has to be due process for these parents, Justice Clement.
Thank you very much, and I'll let my colleagues take it from here.
Justice Kavanaugh.
Yeah, I had a question regarding the availability of the appeal from this order that was entered in November of 17. And the family law section's brief spends a lot of time and very helpful information, right, about what seems to suggest that the Court of Appeals has a practice, perhaps less so recently, at least that seems to be the suggestion of the family law section, but they have a practice of quickly stepping in to remedy errors of this type, right? And so here, though, your client didn't appeal the order that was entered in November until, and it actually moved then for the hearing in January, so a little bit over a month later, and that was granted in January, and then didn't go to the Court of Appeals or then eventually to us until March and May of 18, at which point the hearing was underway. It had certainly been ordered, and I believe it had started in March, which obviously puts the appellate court in a position where the relief that we could afford has already been granted by the trial court. So, but my question is, you know, how does the fact that it wasn't appealed and the Court of Appeals wasn't given the opportunity, or us for that matter, I guess, to remedy that error at the time, how does that impact our consideration of whether there was harm from this error when there was an appellate remedy that wasn't necessarily exercised, or certainly not exercised timely? And I want to couch that in terms too, is maybe you can expound upon, is there something that sort of boots on the ground, actual, you know, how it works in the trial court? Are there considerations that the parties are going to take into account that may factor into whether or not you're going to file an appeal, as opposed to perhaps trying again with the trial court judge, or trying mediation with the opposing party? Is there something maybe that impacts whether or not that appeal goes, you know, why the decision to go to an appeal? But here, by the time that an appeal was taken, the hearing that was requested, or that was in error denied back in November, was already taking place.
Well, Justice Kavanaugh, I'd like to answer that in two parts. First and foremost, as a practitioner, I would tell you that the Court of Appeals, or the Michigan Supreme Court, is always our final remedy, our last remedy, because of the time it takes to get through the appellate process. In this case, I decided to file the motion in January of 18, hoping that the trial court would remedy the errors, because it's always in its client's best interest for the trial court to remedy the errors, not this court. So that's first and foremost. Second of all, I think the important distinction made by the family law section is that previously in the 90s, when such orders were being appealed, these orders were immediately vacated. And I did file an application, a delayed application in March, as well as an application in this court in May of 2018, which was denied for failure to persuade the court of the need for immediate appellate review. But had that order been properly reviewed, in my opinion, the remedy would have been that this court, or the Court of Appeals, would have simply vacated the trial court's order. The problem was, from the beginning, my client was defending herself against an improperly entered order, which changed the scenery of the entire proceedings. Had the Court of Appeals, or this court, vacated the order, which, as the family law section in its brief indicated, used to be the trend in the 90s and early 2000s, then we wouldn't be here before this court today.
Can I jump in real quick, because right when you're on this topic, and I understand you have more to say about it, but if we had, or the Court of Appeals had granted that relief and vacated the order back in 18, the beginning of 18, wouldn't your client have only gotten the evidentiary hearing that in fact was granted by the trial court and was underway at the time of our review? I mean, we could have vacated the order, but the remedy you would have then received was the evidentiary hearing that you were requesting, correct?
Well, Justice Kavanaugh, quite frankly, it was father who was requesting the evidentiary hearing, because he was the one requesting the change of custody. I merely filed that motion in January of 2018 to inform the court that it had made a mistake by entering this order without an evidentiary hearing. So it was father who would have had an evidentiary hearing, not mother. Father was the one who should have requested an evidentiary hearing when he requested a motion to suspend mother's parenting time and to change custody.
So
does that make sense?
Did the order in early 18, the order would have just been wiped off the books, and it would have been incumbent on the father to then, and the trial court to then, follow the proper procedure if he wanted to secure a different order, and the evidentiary hearing should have followed from that, right? But your relief could have been granted of just vacating the order at that time.
That's correct, Justice Kavanaugh.
Okay, thank you.
Justice Welch?
Thank you. I'm wondering, I know the parties after the ex parte order did try to work things out. They stipulated to family therapy and some different efforts. And obviously then later there was the evidentiary hearing. I'm wondering, do those interim efforts which, obviously could have delayed the hearing. How does that play in to this case?
Well, Justice Welch, I read with interest the administrative order published by the Michigan Supreme Court 2020-23 about professionalism principles for lawyers and judges. And as a lawyer, it's my job not only just to argue the case, but to come to a fair and peaceful resolution of disputes and controversies. And quite frankly, by employing alternate dispute resolution methods, as an attorney, I was furthering the goals that this Michigan Supreme Court has indicated are my duties and obligations as a lawyer. And when you're dealing with family law cases where you have a mom and a dad, it's always consistent in the children's best interest to have a peaceful resolution if possible, because it's in no uncertain terms, the strife that children experience as a result of their parents' conflicts have long-lasting scars. And that is why I do not believe it's ever appropriate to hold against a party an effort to come to a resolution outside of the court, such as we did in this case.
Okay, thank you. And I have one more question. What is the ultimate remedy you're requesting? Given, obviously a lot of time has gone by, what would you envision, a remedy being in this case?
Well, Justice Welch, as I know you're probably aware, these children are now 17. My client has not had a Christmas with them in 4 years. I can't undo this, and neither can any of the justices here this morning change the past. But what we can do is vacate that order so that there is a message to these children that this order was entered in error in the first place. This matter can be remanded to a new judge so that we can have the reconciliation efforts take place consistent with what Judge Gleicher envisioned in her dissenting opinion. There is time for that. And not only that, but just for these other families in Michigan that face these similar problems and challenges, that there be an order. I know this court did a great job in Daly v. Ward indicating that, recognizing that these type of orders have long-lasting consequences that may effectively have no remedy on appeal. But if there's a firm message, obviously the message needs to be even more firm to trial courts, that we cannot enter an order that alters a child's established custodial environment on its face without first conducting the evidentiary hearing. That's black letter law, and for some reason that law has been eroded over time. So that's what I'm asking for this morning.
Thank you.
Justice Zara.
Thank you very much. No questions.
Justice Viviano.
No questions. Thank you, counsel.
Justice Bernstein.
Hi, counsel. Good morning. Actually, my colleagues have asked all the questions that I would want to ask, so thank you.
Thank you.
Thank you. We went far over your time, but thank you very much for all your helpful answers. Mr. Gervil-Risch, you may proceed.
Good morning. Gaten Gervil-Risch on behalf of Thomas O'Brien. May it please the court. We're actually not contesting that the trial court did this properly from the get-go, and would, if this had been on review, if this order were actually the order being reviewed right now, the court should reverse it, because it didn't have the appropriate factual findings and best interest analysis that the family law section pointed out it should have had. But that's not the order that's on review. The order that's on review is the final one that was entered. Well, it's not really a final order, but it's an order that was entered after the 9 days of evidentiary hearing. And so the issue is whether there's error in that January 2019 order, not whether there's error to be reversed in the November order, because the November order is no longer in effect. The MCR 3.207 clearly authorizes ex parte orders suspending parenting time pending a hearing based on verified allegations. It says it right there in the rule. That is not in conflict with the Child Custody Act requirement that an evidentiary hearing be held prior to changing the established custodial environment, because the established custodial environment is established over an appreciable time. It takes time to both establish the custodial environment and to change it. And a temporary order suspending parenting time does not change established custodial environment until a considerable appreciable time has passed. So it is wholly appropriate for courts to enter such orders when they feel like it is necessary to protect the children, as the court did in this case.
Council,
to answer
I'll
a few
interrupt you because I
questions.
expect there'll be lots of questions. So let me just turn to those and start with Justice Clement.
Just quickly, if we, it sounds like everyone's agreeing that there was error here. But if we decided that it was harmless, how should the courts deal with what is apparent widespread non-compliance with the CCA? So I think that's kind of the bigger question that's been asked of us.
Well, I would recommend there be immediate review granted. You know, I mean, that's the solution, is to enforce this in the appellate courts. Now, while I agree with counsel that, you know, it shouldn't be held against the parties if they try to resolve these things on their own below, I also believe it shouldn't be held against the trial court if the trial court tries to let the parties resolve this on their own. But that's apparently what's happening here, because the trial court's being blamed for 4 months of delay before even starting a hearing, when it was really the parties who requested that delay. And I think the reason an appeal was not filed during that time period is precisely because they were trying to work it out. If you know, the solution should have been, if they wanted not to have that delay, to, instead of stipulating to it, to appeal an emergency application, saying, look, there were no factual findings made. There was no best interest analysis done. I do believe that there was a record on which the court could enter the ex parte order. The court rules are clear that a verified allegations suffice. But making those assertions alone should have resulted in an immediate reversal to make those factual findings in best interest analysis. Now, that doesn't necessarily mean they get a different result. So if the issue is we need an evidentiary hearing promptly, then they should have requested one on a particular date. And that didn't happen until the motion was filed in January. And at that point, the trial court demonstrated that she was more than willing to reconsider her decision, saying they had very good arguments, and scheduled a hearing almost immediately, but it was put off again. So, you know, this is probably not the case to be resolving this issue, but you know, for those reasons among many others. But that's what I would suggest, is the immediate appeal.
Thank you.
Justice Kavanaugh. We can't hear you, Justice Kavanaugh, but you're not muted, so I don't know what's going on. Maybe your microphone swapped out. Still can't hear you. I'm going to go to Justice Welch, and you can swap your microphone in and out. We'll come back. Justice Welch.
I don't have any questions. Thank you.
Justice Zara.
Thank you. You suggest an immediate appeal is what would have been appropriate, and you're putting more emergency type matters in front of an appellate court, and I'm here to tell you, appellate courts don't generally deal with emergency matters all that swiftly, and perhaps maybe even not effectively. Would not a better solution, or at least an alternative solution, be for us to look at our court rules and impose within a time frame, I don't know if it's 7, 14, 21, or 28 days, that if you're going to issue an ex parte order that impacts the custody situation, that there must be a hearing? And if that would answer if that would address the problem, can you tell me what would you suggest as the amount of time between the initial order and the hearing? Would it be 7 days? Is 28 days too much? 14 days a good day?
Well, it actually does require a hearing if it's requested. You know, that's the problem in this case is that the court rules do require it if it is requested, and it requires it within, I believe it was
21 days.
14 days after the order is served, they have to file a response, and then if a timely objection or motion or request for hearing must be held within 21 days. Now, if they held the evidentiary hearing within that time frame, that would have been 35 days. It would be hard pressed to say that in that time, the established custodial environment would have been altered. And so I think that certainly would have cured the problem.
But let me just ask, why do we have to wait for a party to ask when there's so much going on? If you're going to change, if you're going to make an ex parte order that is going to impact the custodial environment or the current arrangement before it gets to actually changing custodial environment, why can't we as a court say, if trial courts, if you're going to do that, you have to have a full hearing within 14 days?
Well, ordinarily, the rule is that if the facts aren't contested, if the motion's not contested, if the order's not contested, then there's no reason to hold a hearing. Now, I understand that domestic relations cases can be different, particularly where there are children involved. So I don't think it would be unreasonable if the court wanted to mandate a hearing in every instance. That's not what the court will currently do. But if the court wanted to say, judges, you need to hear from witnesses, you need to see the documents, and not rely on verified allegations for longer than a certain period of time, say 35 days, I don't think that would be unreasonable. I think that would be a logical policy.
Okay, well, you started out by saying oftentimes these things aren't contested, which to me sounds like a consent order. I'm not talking about a consent order. I'm talking about when a party goes into the court without informing the other party, presents one side of the case, and then issues an ex parte order.
What I meant was that ordinarily no hearing is required if it's not contested. And so when it is contested, then certainly a hearing is required. And here it was contested, but the hearing was put off at the request of opposing counsel, and then put off again. So there was a solution here. But.
Okay, thank you.
Justice Viviano.
Counsel, I guess stepping away from all the discussion about the rules more generally, and just looking at the facts of this case, the children are now 17, is that right?
That's
Counsel?
correct, Your Honor.
And they've had no contact with their mother and since the order was entered, the temporary order, is that right?
I don't know for sure, but I'm told that's the case, and she's not requested any review hearings, but I'm sure Mrs. Haas can correct me if I'm wrong about that.
Your client currently opposed reconciliation or some effort by the mother to see the children and vice versa?
My client is happy to have that reconciliation when the children are ready for it, if they're ready for it. And the process, I believe, here would be for the mother to petition the court to have that review done to see if that's appropriate at this time.
I have nothing further.
Justice Bernstein.
So, good morning, counsel. I just have a very quick question, and I guess where I'm a little confused, I'm trying to just get a little guidance here is, what would you want the court to do?
I think the court should deny leave.
I'm sorry, please one.
Sorry, go ahead, Your Honor.
No, please.
I don't think vacating is appropriate here, even if the court found error, even in the ultimate order, because at this point, many years have passed. There's a new established custodial environment, and under the Child Custody Act, how that environment was created does not matter. The fact that it was created by an erroneous order would not matter. Those children are in an established custodial environment. So if it is going to be changed again, it would need to be done in accordance with the Child Custody Act. So that would mean a new hearing. The burden would be on the mother at this point, clear and convincing evidence, and so on.
Okay. I have a sense I know how sister counsel will respond to that, but thank you very much thank you so much for your answer.
Counsel, you have a few minutes left if you want to use it.
Sure. One more point, and that's maybe more than one, but the point I want to bring up, I'm not sure I stated it eloquently, is there's a bit of an inconsistency between saying that the parties should be allowed to work out their issues on their own if they choose to do that, in requiring the trial court to hold an evidentiary hearing within a certain period of time, not allowing the parties to do that. And I don't know that there's necessarily a right or wrong answer there. Maybe for the sake of the children, the court should require the parties to work that out within a shorter period of time than what was done here. Be given some time, but not too much of a rope, so that there is actual compliance with the Child Custody Act, despite what maybe the parents want to do in trying to work it out. I believe I've made all the points I want to make. Thank you.
Thank you very much, counsel. Ms. Haas, we used up all of your time the first time around, but I'm going to see if any of my colleagues have any questions for you on rebuttal before we let you go. Are there? Justice Clement.
Thanks. I am curious what your response is to Justice Zara's question about the court rules and making that mandatory instead of waiting for a party to request that hearing. Would that help kind of streamline what I understand you saying that's required regardless, but would that help streamline that so that it's just automatic, where the duty is put on the court to immediately schedule an evidentiary hearing without waiting for a party to disagree with a temporary order?
Justice Clement, as you know, my position is that before the order is entered, the evidentiary hearing must occur. However, I would welcome the suggestion of that it must occur within 14 days, because that most certainly would have changed the outcome in this case. And I just would like to just briefly state that the delay in this matter to try and work things out was only 6 weeks. It was the end of January 2018 through March 18th, 2018. And second of all, I didn't get to touch on the parenting time, but again, the court just issued in February of 2021 updated parenting time guidelines. And in those guidelines, you make it abundantly clear that even teenagers themselves should not be the ones choosing their parenting time. And that's what happened in this case. And it's never appropriate to put these children in the middle, as was the case in the parenting time order in this matter. And I think
can I just ask for some clarification? So if we were to do a required evidentiary hearing where we weren't waiting for a party, in this situation, could the kids have gone and stayed with dad for that 14 or 21 days, and would you view that as a change in the ECE?
Justice Clement, in this case, in which there was absolutely no contact permitted between mom and the children for that period in time, yes, that absolutely impacted the ECE. Mom and child had absolutely no ability for a relationship during that period. And then there's no indication how long an evidentiary hearing would take. In a perfect world, it would happen quickly, but that's not the reality. In this case, it started in March of 18, and we didn't get an opinion until February 1st of 2019. So there's still going to be a passage of time. It's inevitable. It's impractical for this court to believe that it would happen as quickly as you would like it to happen.
Okay, so I'm hearing what you're saying is that this potential court rule change wouldn't necessarily address the factual situation that a variety of cases would be presenting.
Yes, Your Honor.
Okay, thank you.
Are there additional follow-up questions for Ms. Haas?
I just have one. Counsel, did your client ever seek this reconciliation under the judge's order? What was it there for 6-month period and so forth? Have you pursued that route or just this appeal?
Justice Viviano, unfortunately, the way the trial court judge in this case crafted her order, it is entirely imperative on the child's wishes. So in light of the fact that the children and father have remained resistant to a relationship, quite frankly, there's no chance at reconciliation under the way that the order is currently crafted, which, as I tried to explain, I believe is inconsistent with this court's guidelines that it just published in February of 2021, wherein you should not place that burden on a teenage child. And also, unfortunately, in this case, as is abundantly aware in all of the pleadings, the trial court judge in this matter was abundantly biased against my client. And the definition of insanity is doing the same thing over and over again and expecting a different result. And I have fought for years to try to get her a scintilla of parenting time, and it's fallen on deaf ears at every attempt I've made.
All right, thank you, counsel.
Thank you.
Any additional follow-up questions? Well, thank you both very much. The case will be submitted. That will conclude this morning's session. We were supposed to start the afternoon session at noon. We'll start at 12:15 instead of noon to give everybody a chance to grab a bite to eat, and we will return at 12:15. Thank you.